Welcome everybody. We finally got the state's response. Guess we'll get right into it.
Okay, y'all set up? Ready? Okay. Um, Dated April 16th, 2021. Um, to Ms. Sheila Reef, the clerk of Wisconsin Court of Appeals, 110 East Main Street, blah, blah, blah. Read the state of Wisconsin versus Stephen A. Avery, case number 2017, AP 2288, District 2. Dear Ms. Reef, enclosed for filing in the above matter are the original and 4 copies of the response in opposition to Avery's 4th petition to stay this appeal and remand this case to the circuit court. A copy of this response has been served by mail on counsel for defendant appellate. Sincerely, Lisa E.F. Comfer, Assistant Attorney General. And she's mailed those to Kathleen T. Zollner and Stephen Richards. I don't know why she should have just given it to Richards, and Richards could have butt-dialed Zollner about the bones. Okay, State of Wisconsin Court of Appeals District 2, case number 2017 AP 2288. State of Wisconsin plaintiff respondent versus Stephen A. Avery, defendant appellant. Response in opposition to Avery's 4th petition to stay this appeal and remand this case to the circuit court. Introduction. Plaintiff respondent, State of Wisconsin, opposes defendant appellant Stephen A. Avery's 4th petition to stay against this repeal and remand the case to the circuit court for consideration of yet another new Wisconsin 97406 motion alleging the state violated Brady versus Maryland, U.S. 373, 83, 1963, by allegedly failing to inform the defense that a Thomas Sawinski purportedly called law enforcement on November 5th, 2005, to say that he saw Bobby Dassey moving a car similar to the victim's car. The motion on its face shows that it was filed in violation of Wisconsin Statute 802.05, applicable here via Wisconsin Statute 809-84, because it was filed for an improper purpose and without a reasonable inquiry into its factual basis. Staying this appeal and remanding for the litigation of such a motion would result in further unnecessary delay in litigation. This appeal has been languishing for nearly 4 years now due to Avery's repeated requests to return to the circuit court to litigate procedurally barred claims that have no factual support. It is reasonable to conclude at this point that he is not pursuing these claims in good faith, but is merely throwing the proverbial spaghetti at the wall to see what sticks, and delay resolution of this case, Weidenheimer versus Expedia, Inc., and some long case number. Indeed, Avery's new claim is not only unsupported by even a suggestion of corroborating evidence, but this claim is also mutually exclusive with many of the other claims Avery has pursued in the circuit court and on appeal. All of these allegations cannot be true. Avery's reckless disregard of the truth or falsehood of the allegations he is submitting to the courts alone should be reason enough to deny his permission for remand. Moreover, this case has now been fully briefed in this court for nearly a year and has been submitted to this court awaiting decision for nearly 5 months. Like that's Kathleen Zollner's fault, right? Remanding this case to the circuit court to again allow Avery to develop another entirely new constitutional claim is not necessary to decide this fully briefed and long submitted appeal. It would be inefficient and waste the courts and the parties considerable resources that have already been expended and further delay this appeal's resolution. If Avery wishes to pursue yet another claim, the appropriate course is to either wait until this appeal is concluded, conduct a reasonable investigation, and file a new Wisconsin Statute 97406 motion, or dismiss this appeal so he can pursue it now. If Avery has a sufficient reason why his new claim could not be raised in any of his previous 6 motions and some facts to support it, then the claim will not be procedurally barred when this appeal is concluded. If not, the claim is unquestionably procedurally barred already, and another remand would serve only to further delay this litigation and add another incongruous claim to Avery's appellate brief. Avery has dragged out this appeal long enough. This is laughable. He should either dismiss this appeal, conduct a reasonable investigation into his new claim, and pursue it in the circuit court now, or this fully briefed, submitted, and years stagnant appeal should proceed. Background. In 2007, a jury convicted Avery of first-degree intentional homicide for the murder of Teresa Halbach and for possession of a firearm as a felon. His direct appeal concluded when the Wisconsin Supreme Court denied his petition for review in 2011. In 2013, Avery, pro se, filed a Wisconsin Statute 97406 motion alleging that the state had interfered with his ability to confer with his attorneys, that the state impermissibly commented on his silence during closing argument, and that he was deprived of a fair tribunal and ineffective assistance of counsel. The Circuit Court appointed an attorney to investigate the claims and ultimately denied the motion without a hearing in November 2015. In June 2017, Avery filed the Wisconsin Statute 97406 motion at issue in this appeal, alleging that a multitude of constitutional errors occurred during his prior proceedings. The Circuit Court denied his motion without a hearing on October 3, 2017. Avery then filed a motion to vacate judgment on October 6, 2017. He additionally filed a motion for reconsideration on October 23, 2017, followed by several supplements to that motion between October 31st and November 17, 2017. The Circuit Court denied all of these motions without a hearing on November 28, 2017. Avery filed a notice of appeal from the Circuit Court's final written order on November 30, 2017. On June 7, 2018, this court retained jurisdiction but remanded this case to the Circuit Court to allow Avery to file another state 97406 motion to litigate a Brady claim. The Circuit Court denied that motion without a hearing as well, and the record was transmitted back to this court on November 25th, 2018. Strangely, there's little mention of the fact that the reason the Circuit Court brought it back in the first place was because of the possible validity of the claim. Otherwise, why would they remand it? The fact that Judge Flowers denied it is not really the issue. It's the fact that the the appeals court said, you should maybe think about this a little harder, Judge Flowers. On December 17, 2018, Avery filed another petition to stay this appeal and remand the case to the Circuit Court for Avery to litigate a motion for post-conviction DNA testing of bone fragments collected before trial pursuant to Wisconsin Statute 97407. On December 28, 2018, this court denied the petition, stating that the scope of this appeal is limited to a review of the Circuit Court's orders denying Avery's Wisconsin Statute 97406 motions, and therefore good cause to remand had not been shown. This court gave Avery a further extension to February 1st, 2019 to file his initial brief. On January 24th, 2019, a week before his initial brief was due, Avery filed a third motion to stay this appeal and remand the case to the Circuit Court. This time he sought to pursue a new claim that the state had violated his due process rights by releasing a portion of potentially human bone fragments to the Halbach family for burial, roughly 5 years after Avery's trial. This court again remanded the case to the Circuit Court to allow Avery to pursue this additional claim. The Circuit Court denied it without a hearing on August 8, 2019. Again, same deal. It's not the fact that Judge Flowers denied it. It's the fact that the Circuit Court said, you may want to look at this. This appeal then finally proceeded. The briefing was concluded June 26, 2020. On November 9, 2020, the case was submitted to this court on briefs. The only step left in this case, on this appeal, is a decision from this court. On April 12, 2021, long after the briefing had concluded and after this case had been submitted to this court for 5 months, Avery submitted yet another motion for remand. This time he claims a new witness, Thomas Sawinski, had come forward to post-conviction counsel on April 11, 2021, and said that while he was delivering newspapers to the Avery salvage yard on November 5, 2005, he saw Bobby Dassey and an unknown older man pushing a RAV4 up a hill. Avery claims that Sawinski called the Manitowoc police to report this later in the day, but police were not interested in this information. Avery claims the state suppressed this information and therefore violated Brady 373 U.S. at 87. He seeks to remand to pursue this claim in the Circuit Court. Relevant law. Avery is permitted to petition this court for remand to the circuit court for action upon specific issues, pursuant to Wisconsin Statutes 808.075. The decision to remand is left to this court's discretion. See State versus Myers. The rules of civil procedure apply to appeals and to litigation of Wisconsin Statute 97406 motions, provided they do not conflict with any specific rules of procedure spelled out elsewhere for such actions and context of the rule does not manifestly require a different construction. Wisconsin statutes, a whole bunch of them, State versus Henley, etc. As relevant here, Wisconsin Statute 802.05 provides that by presenting a submission to the court, an attorney is certifying that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, all of the following. There's a footnote, we'll get to the footnote after. The paper is not being presented for any improper purpose, such as to harass or cause unnecessary delay or needless increase of the cost of litigation. B, the claims, defenses, and other legal contentions stated in the paper are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. Or C, the allegations and other factual contentions stated in the paper have evidentiary support or, if specifically so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. And that footnote, I'm going to go down and read the footnote, then come back. The footnote to that, there is a fourth prong, but it is not relevant to the pleading here, so they didn't discuss it. So there would be a D, but it wasn't relevant. So on to the next paragraph. The purpose of the statute is to place a professional obligation on the attorney as an officer of the court to satisfy herself that there are grounds for the action, defense, or motion. Gaddis versus Cross Products Incorporated, long case number. The duty to conduct a reasonable inquiry mandates that an attorney validate the facts being alleged before proceeding with a claim. Belich versus, oh boy, Zamazik, 224 Wisconsin 2D, again, a long case number. The reasonableness of an attorney's inquiry into the facts supporting an allegation is determined by considering the following factors. 1, the amount of time the attorney had to investigate the claims. 2, the extent to which the attorney had to rely upon his or her client for underlying facts. 3, whether the case was accepted from another attorney. And 4, the complexity of the facts. This provision has intentionally been crafted to replicate Federal Rule of Civil Procedure 11, C. Riley versus Isaacson. Accordingly, the courts can also look to cases interpreting that rule when applying Wisconsin Statute 802.05, according to Riley. Argument. Remanding this case for Avery to pursue another new constitutional claim at this late juncture would be inefficient and unduly prolong this appeal. Avery again asks this court to stay his appeal and remand his case to the circuit court so he can litigate another new Wisconsin 97406 motion. The issue Avery claims he would like to pursue is an entirely new claim, alleging a Brady violation based on a purported new witness who provided post-conviction counsel with an affidavit on April 10, 2021, alleging that he told law enforcement about seeing Bobby Dassey move a car on November 5, 2005 that resembled the victim's vehicle. As before, Avery does not seek remand for fact-finding on a specific issue raised in his earlier motion. His motion is another request to pursue a new constitutional claim. Avery admits that this is a new issue and that counsel purportedly discovered on April 11, 2021, Avery's motion. This case is now in a distinctly different procedural posture than it was when this court granted Avery's previous motions for remand in the name of judicial efficiency, however. This case has been fully briefed since June 2020 and has been submitted to this court for a decision since November 9, 2020. These parties have already expended an enormous amount of time and effort on briefing this appeal. Presumably, this court has already dedicated a considerable amount of this court's scarce time and resources to addressing the issues already briefed as well. Given that this appeal is nearing its end, rather than in the pre-briefing posture it was when Avery previously sought remand, it makes more sense to conclude this proceeding and for Avery to then file a new Wisconsin 97406 once this case is remitted to the circuit court. As previously noted, a Wisconsin 97406 motion may be made at any time, according to 97406, and if the court finds a ground for relief asserted, which for sufficient reason was not asserted in previous Wisconsin Statute 97406 motion, the new motion is not subject to the procedural bar of State versus Naranjo. So in other words, I think he's saying that they can put this one down and if for some reason the court rules against them, they have another basis for a new claim. If Avery can establish a sufficient reason for failing to raise this claim in the motions currently under review, the claim will not be barred, and he can file a new Wisconsin Statute 97406 motion once this appeal has concluded. If he cannot establish a sufficient reason for failing to raise this claim earlier, the claim is already waived and the procedural bar already applies, State versus Lowe. It would unduly prolong these proceedings to further remand now after considerable time and effort has been expended by the parties in this court, and this appeal is nearing conclusion. This court should deny Avery's request for remand. Avery did not. Number two. So just to be clear, reason number one was it's too late. Reason number one, it's too late. You shouldn't do it now. You're too close to a decision. Reason number two is Avery did not conduct a reasonable investigation into his new Brady claim before filing this motion in violation of Wisconsin Statute 802.05. At a minimum, the reasonable inquiry standard requires that at least some affirmative investigation on the part of the signer. According to Bellick 224, false swearing is a felony, according to Wisconsin Statute 946.32, and Avery's attorney has an ethical duty not to present false statements to the public, the state, and the court. Avery's motion shows, however, that his attorney conducted no affirmative investigation into this claim before filing this motion for remand. Avery's claims in his motion that Mr. Sawinski came forth on April 11th, 2021. Avery then filed the motion at issue here on April 12th, 2021, with the only factual support alleged for it is an affidavit from Sawinski himself, full of vague allegations. Avery's motion does not state that his attorney made any effort to substantiate this claim. His attorney did not attempt to perform an open records request with Manitowoc County to see if this conversation ever occurred or whether any record of it existed before filing this motion. She did not try to learn who this female officer Sawinski claimed he spoke to might have been, or even which female officers were employed with Manitowoc at the relevant time. She apparently did not press Sawinski for any specifics about this allegation that could allow her or the state to investigate it. Indeed, Avery's attorney apparently did not perform so much as a phone call to try and back up this information before filing this motion. There is no excuse for this lack of verification. There was ample time to investigate this allegation. As explained, there is no time limit for bringing a Wisconsin 97406 motion, and if Avery has a sufficient reason for failing to raise this claim in his previous motions, it is not procedurally barred. If he does not, the claim is already procedurally barred, and pursuing this motion for remand is a fruitless endeavor anyway. Avery's attorney did not have to rely on Avery for the factual foundation of the underlying motion. Indeed, nothing in Avery's motion suggests he's even aware of this story, let alone that he provided any facts about it. As mentioned, there were several ways to investigate whether there are any factual underpinnings for this tale. It was not impossible to investigate such that Avery's attorney had to rely on Sawinski alone. This case did not originate with a different attorney, and post-conviction counsel has hardly made it a secret that she has been pursuing post-conviction relief on Avery's behalf for the past 6 years. And finally, with this, while this case is complex, the allegations relayed by Sawinski and underlying the elements of the purported Brady violation are not. To perform an adequate investigation before proceeding with a claim, it is clear that an attorney may not simply rely on his or her client's word, according to a statute from or a case named Bellick. It follows then that neither may an attorney rely simply on the word of a person like Slawinski, someone who appeared out of the blue for the first time in 15 years after this case began and long after Avery's appellate brief was filed. This despite extensive media coverage of this case, particularly during the 5 years this post-conviction proceeding has been proceeding, and just fortuitously happens to provide the exact exculpatory story Avery has been seeking, yet for some unexplained reason he failed to provide it to Avery's attorneys until now. The need for an attorney to approach such claims with skepticism and to at least conduct some type of investigation before filing an affidavit attesting to the story's veracity is particularly heightened, whereas here, the attorney has offered a $100,000 reward for such information. Technically, yeah, technically the killer, the $100,000 reward is for leading for the killer to go to jail, not for Stephen to get off. A paper filed in the best of faith, even when the lawyer is convinced of the justice of the client's cause, is sanctionable if counsel neglected to make reasonable inquiry beforehand, according to a case called Ryland. The investigation need not be to the point of certainty to be reasonable, according to Bellick. Nonetheless, the signer must explore readily available avenues of factual inquiry. A statement that is offered as positive fact but is actually an extravagant inference from vague recollection does not satisfy the requirement, according to a case named Kelly. Avery's attorney did not conduct a reasonable inquiry into this claim. Denying remand in this situation is appropriate. Number 3, again, the major ones. The first one was it's too late. That one, that one, she didn't investigate enough, and thank you. And this one is Avery's many remand requests have been filed for an improper purpose, warranting denial of his latest request. That one's kind of confusing. So he's made too many things. He's complained too many times, and therefore you should just deny it. The obligations listed in Wisconsin Statute 80205 are independent, meaning that the statute has been violated if any of the prongs have been violated. Avery's disregard for Wisconsin's rules of procedure and his persistent serial filing show that they have been made for improper purposes, to delay proceedings. Because you know why? Because he wants to stay in jail longer. To continually, to continually change his position, to make it difficult for the state to respond to his ever-shifting allegations, and to frustrate the court's ability to reasonably evaluate his claims by burying them in paper. Improper purposes does not necessarily refer to bad faith or intent to harass. Indeed, any reckless disregard of the duty owed to the court can suffice. In this course, Mariso versus Lafayette City Parish Consolidated Government. Avery has continually misrepresented the facts, misstated the law, and made claims grounded only in speculation with reckless disregard for their truth or falsity. Avery's conduct shows that his many filings, including this one, were filed for an improper purpose. Avery has now filed 6 motions alleging claims that could have been raised in his first Wisconsin Statute 97406 motion. He has ignored and attempted to circumvent by continually labeling his successive motions as supplemental, despite the fact that each of his previous motions has been denied when he filed the new ones, meaning that they could not be supplements to his previous motions. State versus Evans, 2004. Okay. He has pursued diametrically opposed claims and submitted evidence that he reasonably should know cannot be all true. Compare R with he's giving paragraph citations that allegedly contradict, accusing Strang and Buting of being ineffective for failing to establish Ryan Hilligus as the only possible third-party perpetrator and claiming Sergeant Colburn planted the RAV4, then alleging they were ineffective for failing to establish Bobby Dassey as a possible suspect with the same evidence, and now claiming Bobby planted the RAV4. Further, Avery has inappropriately changed his arguments or raised new ones in his reply briefs, giving the state no opportunity to respond. See, for example, Avery's appellate brief, pages 4 through 7, Smith Corp versus Allstate Companies, yada yada, long case reference. He has buried and burdened both the circuit court and this court with thousands of pages of exhibits, many of which were unnecessarily repetitively filed multiple times, and many that were never discussed in Avery's filings. Compare R141, okay, another reference for specific page numbers that we don't have handy. He has leveled completely unjustified accusations of bad faith against the state. Again, some specific page number references in briefs. And finally, he has disingenuously presented his claims to this circuit court by affirmatively misrepresenting how and when he raised his claims below, changing his claims on appeal, adding new allegations he never presented to the circuit court, and materially misrepresenting the record. Again, per specific references. In short, Avery has engaged in a pattern of gamesmanship that offends the rules and demonstrates a cavalier lack of candor with this court and the circuit court, according to Osborne versus Bell Helicopter Textron. The state is not seeking sanctions here. However, this pattern of conduct shows that Avery's belated remand request has been made for an improper purpose. Yeah, he wants to stay in jail longer, right? That's what he would love it if he spent another year in jail. That would be awesome. This court should deny his motion. Again, if Avery no longer wishes to challenge the circuit court's decision denying the claims he raised in the Wisconsin Statute 97406 motion at issues here, he may voluntarily dismiss this appeal. As noted, his new claim is mutually exclusive with some of the claims that he raised previously regarding what theory of defense he believes Strang and Buting should have pursued, and cannot be squared with many of the allegations in his appellate brief. The process of winnowing out weaker appellate claims and focusing on those more likely to prevail is the hallmark of effective appellate advocacy. Smith versus Murray. Isn't that great? That Josh Call, the son of a corrupt DA, is explaining to Kathleen Zellner, who has the world record for exonerations, what the hallmark of effective appellate advocacy is. Isn't that special? Alternatively, if he does not wish to give up his challenge to the circuit court's denial of issues raised in the motions at issue here, he must wait until this appeal is resolved and then determine how he wishes to proceed. But staying the appeal and remanding the case to the circuit court for fact-finding on another entirely new claim that Avery has not attempted to verify is not appropriate. Avery's request for remand is contrary to Wisconsin Statute 97406 prohibition on successive post-conviction litigation. Conclusion. The litigation of a new Wisconsin State 97406 motion alleged violation is not a specific issue related to the order Avery is appealing. It is a new and separate action in the circuit court. Avery has alternative courses of action that do not require further delay to this fully brief submitted and 4-year stagnant appeal. This court should deny Avery's petition dated the 16th day of April 2021. Respectively, Josh Call, channeling the late Peg Lautenschlager, and Lisa Comfer, Assistant Attorney General, Wisconsin Department of Justice, and then the address, and then the phone call if you guys want to call him and tell him what kind of schmuck he is, you can do that. All right, what do you guys think?
Can I just state it is awfully ballsy of them to bring up gamesmanship?
Yes, you can.
I'm appalled.
For me, when we were researching today on Discord, Carla found some, to me, pretty damning information in regards to this witness. They went through and interviewed a bunch of people in the area and waited till the 16th to interview the spring tubes right by Avery's house. And for some reason in this report that was written up, the Herald Times is mentioned, yeah, and delivery times are mentioned.
We
I actually sent you the picture.
We don't have the questions that were asked. It's just
right.
Summary of what he said to them. But I find it strange that he's bringing up the Herald Times.
I sent Billy the picture so he can put that up so y'all can see it. But he literally asks him, and I don't. The way it's worded, it says that Walter stated that the paper was delivered at 9:30. I'm sorry, I delivered papers before, and there is no way you're allowed to deliver papers that late. And in fact, Carla also looked. The paper Monday through Friday had to be delivered by 7, and on the weekends it was 8. So I'm assuming that Mr. Walter, like I said, I'm assuming that he picked up his paper out of his mailbox at 9:30.
We don't know. We don't know what the questions
I
were
said
asked.
that's what I'm assuming because the paper
You can't assume anything. You just know that they brought that up for some reason.
Right.
We need to get the actual audio interview, or Zellner does for sure.
Right. And like I said, Carla did verify with Herald Times, their delivery times through the week are 7 a.m. and 8 on the weekends.
So are you suggesting that the reason that they were asking about this was possibly that they were trying to dig into Sawinski's claim that they did receive?
Yep. Well, that's the
It
thing.
doesn't make much other sense.
Zellner needs to find out what phone number he did call, because there's 3 dispatch lines that were taking information, and we only have audio from 2 of them. So, and the one that we don't have no audio for was put in the paper, and it was on the news too. To call Manitowoc County Sheriff's Department with the 920-683-4200. We have the 4201 and 4202 numbers, no 4200.
So we can expect Zellner's response to this brief to be that, I'd asked Manitowoc for the audio, except for they repeatedly have indicated that they don't have it. Right?
Okay, Pam Girl was asking for clarification of what this is.
This is the state's response and why the Court of Appeals should deny it.
I think she's asking about what we're talking about right now, and that's what I actually sent it to Billy. It's off of a DCI report where an interview was done on this.
Put it in the chat here, because I ain't gonna get it there. I don't have it open.
Okay, let me see if I can. I don't think I have screen share on here, dude.
Well, you suck.
Well, I'm sorry. Jeff, can I send it to you?
Will I be able to present? Yeah, I could present. Yeah, I can do that.
Here it is.
Put it in Discord. You got to put it in.
I sent it to you in a DM in Discord.
Okay, give me a second.
So this is a portion of that written interview with Walter Spring Tube on the 16th of November.
Do you have the link to the actual DCI report? That'd probably be better.
Carla had just posted screenshots of it. She was going through and looking at phone numbers. It says it at the top of the page.
Okay.
I got it.
Can I
I'm not
say
a very
one
fast computer operator. Maya, by the way, it's good to see you again.
Yes, it is.
Good to see you too. I just want to state one more obvious fact that kind of makes me giggle a little bit inside, is that you can clearly tell from this that they are frustrated as all get out. And I love it. Like, you can tell they were just irritated by the paperwork and the more stuff that she's piling on top of them. And I think she's doing it on purpose because she's expecting them to make a mistake like they have multiple times.
Yeah, I agree with you. I don't think it's what I would call undue, but he's got to come. They have to come. Yeah, so I find it laughable, and I said it a couple times during that reading while Millville is getting that thing up, that that what she's interested in is a delay, right? She's doing this case pro bono. She's not getting any money from Stephen. The Averys are pretty much broke. She's shelled out over $300,000 of her own money, yet she's delaying. She has a reason to delay it further for some reason. I mean that does not make sense prima facie, right? It's nonsense. There's no value to her in delaying it for delaying's sake. So there's that, and they got the $100,000 thing wrong. It's not $100,000 for exonerating evidence for Stephen getting out of prison. It's to find the real killer, right? That's what it is. Now I don't disagree that Sawinski definitely could have 100,000 good reasons to make the story up if you were doing that, and perhaps there is some due diligence that's applicable here.
Big Jeff.
Yeah.
Jerome from French Wrecking Crew is asking what the Casey's options are. We spoke with Travis, so if you'd like to explain that to him.
So maybe he could clarify that question a little bit. So what could happen here is that the court could say that this motion is denied, in which case we go back to where we were before Sawinski ever came forward, and the 3-judge panel can rule on this, right? If they say yes, then what has to happen is this will get remanded back to the same court as Judge Flowers. I'm not sure if it's Judge Flowers that would get it, or she'll finally recuse herself. And she could do a bunch of things, right? She could have an evidentiary hearing just on the Sawinski matter, if she wanted to, or she could dismiss it out of hand. In which case, if she does that, which is, if they actually grant this, the most likely thing, in my opinion, is that Judge Flowers, rejects this without a hearing, as she's done every single time. And if that's the case, then it's prepare a new brief time. We're exactly where we were with the Bones. So they'll have to take the current brief, and she is going to say that Judge Flowers abused her authority when she dismissed this without a hearing because of this and that. And she's going to have to fold that information into her current brief and let the 3-judge panel, and then the state will get to respond, and then she'll get to respond back. So we're probably set back into anywhere 12 or more months. It's been 5 months so far.
Well,
so she's going to be responding to this. Kathleen's going to respond to.
Oh yeah, she has one. She does have her response.
Then the judge will make their ruling.
Yes.
They keep talking about, instead of waiting on this, she can go and get this and get new evidence on this if she dismisses this. This is the same crap they've been pulling.
Oh yeah. She's not.
How many times are you going to mention all the times that she was denied?
Yeah. What was particularly aggravating about that I found mired was that what they really failed to mention is that it's kind of unheard of for something to get remanded back to the circuit court, and it's happened twice, right? Once for the VLECD and once for the Bones. So it's she's doing all this stuff, but her motions are succeeding from the perspective of she's getting the circuit court to do what she wants them to do. And it's Judge Flowers that's throwing up her hand, and they're trying to, she's not. I mean, they're not fooling the circuit court that the circuit court is the one that sent it back. It's just a lot of hot air, just like you're saying, right?
Mm-hmm.
It's particularly aggravating. So yeah. Now I honestly think that their best argument that they have in this is that she. She didn't do. It's not clear how much investigation that she did, right? And it does seem like he came forward pretty quickly, and that she got it out the door pretty quickly. She might argue that, look, this is a real Brady violation if this happened. There's no Manitowoc audio. What can I do to investigate it? If the state has other stuff that they should have given me, I don't have it. I purportedly should have everything. If there is something, that in and of itself is a Brady violation.
Well,
She
not
might.
like, but let's discuss how close was she to having an agreement with them on access to evidence before she was denied yet again.
Oh yeah,
But they
yeah, absolutely.
dropped everything last time.
Yeah,
There's
that
a little act.
that was when they had agreed to. Just in case people don't know, that was when the state Fallon himself had agreed that she could do some testing on the RAV. And then when the Bones issue came up, Judge Flowers, surprisingly, because they were going to do it, and then we got the surprise ruling from Judge Flowers, said nope, this is denied, and no more testing is going to continue. How obvious is that? What kind of idiot do you have to be to believe that this wasn't done in coordination with, oops, we have to get this thing out of this court real fast, and have a higher judge say that there's going to be testing? I mean, it's just have to be an idiot to think otherwise. Right? Am I wrong? So yeah. So I'm not sure that we got your full answer there, Jerome. If you need more than that, then ask again.
Let me see.
So, sorry to just. So, yeah. What was that your? Was that
I'm
the
trying to
extent
see if I can share. I can't share.
No, you can scroll up. It's only the bottom. It's only the bottom paragraph. If you scroll up.
Profit.
Does he say it? Only. Well, I assume that not everybody heard that. Okay.
Oh.
Okay. Let me call up the briefing. Okay.
Let me look and see if I can see which one it is.
So, like I was saying before, I think that their best argument is that she didn't have much time to, or she didn't, what they didn't do her due diligence in investigating it, and I think that, well, it's be interesting to see what she says back. But when Travis was here the last time, I think what he said, and this is me getting it wrong, not Travis if I get it wrong, was that if she doesn't bring it up, if she knew about it while this appeal was active, and she didn't bring it up, then she would be procedurally barred from bringing it up in the future. That's what I thought I understood from Travis. So but I might have that wrong. And there's that, and there's number two. If they might be on the precipice of ruling for all she knows. So if there is no way to, if there is no way to verify it, then there is. When she said they did nothing, well, we know that he did deliver the paper. That was even confirmed by Brad Dassey, right? Whose cousin was aware that he did that particular paper route. So I mean, you can't say she didn't do anything to verify it, right? Maybe there's a phone call, and we already have the list of female officers that work at Manitowoc. We put that up yesterday, so it's not clear to me what value added there is there.
I think that she didn't, because she didn't provide anything other than his picture. She didn't include any of her due diligence in there.
Yeah.
So basically, they're saying, "Show me your cards."
As usual.
Yeah.
So we'll see what she spits back. I'm sure she'll spit back, something along the lines of, if I had the Manitowoc, if they have anything to show me with regard to him making a call there or not, I should already have it. And the fact that I don't have it is another Brady violation. I think that's the argument that she'll make. We could have if you called us, we could have compared it against this list of incoming calls, which I haven't provided you. Or I could have listened to the Manitowoc audio for November 5th, which I already said that I don't have, right? So they kind of paint themselves into a corner a little bit with that response, but nonetheless, it is a little bit under It is a little bit underplay. So I'm not a lawyer, so I don't know. I probably used the wrong word there.
Nice. I think this was 100 irritation response, which
Yeah.
is because you can hear it. Just, I mean, it's written out and plainly typed in. It's got all these references, but you can just hear the agitation in their writing, and I love it. I
Yeah.
love that she's getting under their skin so much. Just like what was that email that surfaced of him? When it came to everything, talking about how she is really pissing him off.
Oh, I didn't see that. I didn't see that email. I thought you were going to talk. I thought you were going to say the one where they talked about the 8mm film of the flower.
Yeah, it's the same email.
Oh, it's the same email. Okay, yeah. I don't recall her that being aggravated with her, but I do recall that yet being another breed.
I did find the list.
I highly believe there is somebody in there that drop in little tidbits. Why would this email have even come up in a FOIA request? I know it was supposed to have come up in a FOIA, but I highly believe there's somebody on Steven's side there dropping little tidbits to let stuff out.
It could be. It wouldn't surprise me. There are a lot of people out in Wisconsin that think he got a total screw job.
Yeah.
Even people in the Attorney General's office at the time, and they knew he was getting wrong for Penny Bernstein and Gregory Allen.
Yeah.
So it wouldn't surprise me if there are justice-minded people actually out there.
Well, it's not just that, but how many people at this point have they screwed that at some point are going to want vengeance? They're going to want own revenge just because of what they've done to them.
Yep. That's very true. Let me try and copy it into Discord. Can you see Discord, Millbilly? I pasted something into Discord. In the PDM. That might work. Oh.
Where in Discord you put it?
I DM'd it to Millbilly. That's with regard to the interview of the people at the end of the road. I can't remember their name.
Spring Tube.
Spring Tubes. Thank you. Yeah. So yeah. So are there any other questions in the chat? Oh yeah. Well, I only got the screenshot from.
I'm thinking I might have found it. No.
Yeah.
Yep, we'll show it.
Any other questions in the chat?
I will look here, sir.
Yeah, I apologize. I can't even see the chat because I'm in this on my phone. So
Yeah.
YouTube not being able to be open in the background.
I'll go and find that DCI report, and then I'll just post a video about it, I guess. But thanks, y'all,
Hey,
for tuning in,
Justin.
and we'll see you next time.
Thanks, guys.
All right. Later.